Welcome back to the morning show here on Arise News.
There seems to be a battle of wills going on between Nigerian banks and the major telecommunication companies over justification or the lack of it for the imposition of additional costs on messaging and data usage for customers in the country. MTN started it all with an early morning bulk message to its clients last Saturday. But as the back and forth continues unabated, there are hints that this situation may eventually be decided in the law courts, or will it not? For a perspective on this, we're now being joined here by Liborous Oshoma, the lawyer himself, and he will also be offering his thoughts on the controversy trailing the impeachment of the Kogi State Deputy Governor, with a couple of weeks to a governorship contest in that state. Liborous Oshoma, good to see you again on the morning show.
Good morning.
Good morning. Thank you for joining us.
Always my pleasure. Yes, thank you very much. But let's start with Kogi. I mean, everyone has said what has happened there is illegal. But again, the Constitution, talking about the procedure for removing maybe governor or deputy governor, or even president or vice president, places much emphasis on in the opinion of the Legislative Assembly. Is the problem in Kogi one of the lack of clarity in the language of the Constitution, or just, misconduct on the part of both lawmakers and their sponsors?
The language of the Constitution as far as this Kogi matter is very clear. Like we say in law, when the words of a statute are clear and unambiguous, the literary meaning should be applied. And Section 188, subsection 8, the words of the Constitution are clear, so clear and unambiguous that even a primary one pupil would be able to understand where the panel reports to the House that the allegation had not been proved, no further proceedings shall be taken in respect of the matter. That's the
word is shall.
Yes. It's a compulsion.
Yes.
Yeah.
It's not made.
It's not made. So here, it's not even in the opinion of the assembly members to consider. It says when the panel, because the essence of
but the original charge will be in the opinion, what the assembly considers to be gross misconduct.
Yes, that's
so
the
is
original.
It possible that even if the panel says we can't find anything, the allegations are unfounded, can the assembly still say, well, still in our opinion, this man is guilty of gross misconduct and he must go?
Funny enough, the Supreme Court had the opportunity of taking a bite on that this interpretation, and in Ladoja's case and in Peter Obi's case, the Supreme Court looked at the entire gamut of Section 188. Before now, also subsection 10 of Section 188 says no proceedings or determination of the panel or of the House of Assembly or any matter relating to such procedure or determination shall be entertained or questioned by any court. So most times what happens is once this kangaroo impeachment takes place, they would quickly latch onto subsection 10 to say the court can't question it. And then the Court of Appeal in Ibadan, in Ladoja's case, and the Supreme Court in Peter Obi's case, said, look, you cannot invoke subsection 10 when you have not complied with subsection 1 to 9 of section 188. And so in the same vein, that all these sections must be read together. Yes, in your opinion, whatever you think is gross misconduct, that is your opinion. And that's why the lawmakers also, because this is something that has to do with the people that elected the holder of that office. And so to that extent, if it must be removed, it shouldn't be within the dictates of the assembly alone. Must also involve the judiciary. And that's why, if you also look at subsection 5, it says, in the opinion of the chief judge, people whose character, who are people of integrity, and because you involve the judiciary in that proceedings, you set up a panel, because you can't be the judge, the investigator, the accuser, and at the same time, the man who will carry out the execution. So we are conducting an investigation you have raised allegation. So allow a different body to investigate. And if they investigate and they say, look, this allegation had not been proved, the matter ends there. And so the proceedings for impeaching a governor, really, or a deputy governor, rises and falls with the panel of 7. And so in the case of Kogi, it fell flat with the recommendations from the panel of 7. And so that ordinarily ended the matter. For me, there is no impeachment. And so even what we have is an aberration. So the new deputy governor that had been sworn in ought not to have been sworn in, whether it's a chief judge of the federation or a chief judge of the state. There is no vacuum in that office in as far as the law, the constitution, the ground norm is concerned. And so you cannot be swearing in a deputy governor in an office that, had not been vacated. Because what the State House of Assembly did, for me, is laughable. It's akin to what happened in Rivers State when Amechi was governor. The attempted impeachment by 5 members of a 36 House to impeach a governor. Imagine if that had happened. Would you have said, look, the people have impeached the governor, so the governor should go to court and go challenge whatever transpired? That would be mocking the law, the constitution, and democracy. And that's what we are saying here. And I also am not too happy with the silence of the Attorney General of the Federation. On this matter, I expected a legal opinion from him to the state governor to say, look, the world now is a global village, and we expect, state governors to uphold the tenets of our constitution. About a situation where they all maintain a conspiracy of silence.
Isn't the state governor himself, the instigator
yes, that's what I'm
the
saying.
Entire process?
That's what I'm saying.
So why would you expect good faith from him?
But from the Attorney General of the Federation, who is not only the legal advisor of the, also the chief law officer of the state.
He's thinking along party lines.
Of the Federation.
He's thinking along party lines, unfortunately. I think you expect too much. No, but can I ask you now that we've seen, you've clarified this issue, the Chief Justice Ajana did commit this huge faux pas by swearing in Mr. Onoja. What happens now? What are the remedies available to Mr. Chuba? And what should sort of disciplinary penalties, what should really happen now with the Chief Justice of Kogi State for this kind of a breach?
I think the NJC's hammer should come down heavily. You remember in Rivers State, the NJC didn't waste time in suspending Justice Agumagu when he accepted to be sworn in as a chief judge when the NJC had recommended Justice Daisy. And so in this same case, in similar vein, a chief judge set up a panel to investigate an allegation, and the chief judge also is knowledgeable in the provisions of the law. And the panel, headed by Senior Advocate of Nigeria, came up with the fact that, the allegation had not been proven. And so I do not now expect a chief judge, in an attempt to save his job, to hold on tenaciously to that abuse of the law that you swore to uphold. We need, like you said before the program, we need to begin to use people as example. The law also, the society need to protect institutions, protect people. A situation where a chief judge, no matter how much the state governor would ridicule that office, it would have been better, because you have attained the highest peak you can in the profession. It would have been better for the chief judge to throw in the towel honorably to say, you know what, at this stage, because he declined initially, at this stage, I cannot do this. I would rather step aside, leave the office, than, be part of this illegality that had taken place. That's honor. But the situation where he had gone ahead, in spite of the law, to swear in a deputy governor. I saw him in the papers. You saw him genuflecting to the,
But Liborous, if we may apply the brakes there, let's see if we can problematize it a little further. If you look at Section 188,
yes,
the only function that is assigned to the chief judge is to set up the panel.
Yes.
Right? And he did that in setting up the 7-man panel. Now, the report, after the process, after the panel, does not go to the chief judge. The report is submitted to the House of Assembly. The chief judge has no further role in the matter. Is it possible that the chief judge may have assumed that it is not within his duties, right, to begin to protest on behalf of the illegally removed deputy governor? The option of going to court, that remedy being available to the illegally removed deputy governor. And then he will go ahead and swear in the person that has been presented before him and assume that, they agreed to go to court.
Because
he cannot go to court on behalf of the
chief judge does not live in the moon. lives in the same state. And then also the Constitution cannot spell out everything is and was. The Constitution is silent on who the report should go to. But I also want to presume, like you have said, that the Chief Judge the report does not go to the Chief Judge. I also want to presume that being the person who set up the panel, the report will go to him for onward transmission to the Speaker who had requested him to set up a panel to investigate the allegation. And so that's why I said these things, they don't exist in vacuum. The Chief Judge is aware of the report. The report is a public knowledge. The Chief Judge also is aware of the provisions of the Constitution, Section 180, subsection 8. And the report also is a public knowledge. The members of the committee, the chairman of the committee, senior advocate, came up publicly to say that this allegation had not been proved. And so to that effect, why did the Chief Judge in the first place refuse to swear in what do you call it? Why I can't describe him as a deputy governor.
The former chief of staff, then.
It's the chief of staff.
Okay.
Why did the Chief Judge initially refuse to swear him in? For me, I think because we hold on tenaciously to offices, and so to that extent, it's become easy for him to say, well, let them go to court. Let them go to courts. And knowing fully we're here, like they say, the windmill of justice grants slowly but surely. But we forget that justice delayed also is justice denied. The two must coexist. And so in this case, the elections are around the corner. So, and we know that the matter will not just end at the High Court to get to Supreme Court. The earliest time we will take that matter to get to Supreme Court and back will be 1 year. And by which time it will end up as an academic exercise. So where is justice to the man? Where is justice to the state? Where is justice, most importantly, to the Constitution of the Federal Republic of Nigeria?
And that's what I was going to ask you, because this is another serious shock to democracy that we're looking at here. And what's worrying is that so much violence has already taken place in Kogi since the elections or since the election period started. Where does this now leave the people of Kogi in terms of their own safety too? Because it doesn't look like this is going to play out smoothly in the states at all.
Unfortunately,
we only have a couple seconds.
Unfortunately, the elections here are still characterized by...
Or maybe Liborous should take the question when we return from break. So you have some time to reflect on it. We'll take a short break now, and we'll be right back. It's still the morning show here on the Arise News channel. Welcome back to the morning show here on the Arise News channel. Still with us in the studio in Lagos is Liborous Oshoma, a lawyer who has been talking about the impeachment, the purported impeachment of the Kogi State Deputy Governor. Before we went on break, you were responding to a question that had been raised by Leila.
It's unfortunate that our elections are characterized by violence, ballot box snatching, irregularities, and then after the election, the conduct, the outcome is presumed regular. And so the onus is on you who's alleging irregularities to prove that the irregularities were substantial to affect the outcome. And so that's where the problem really is. And INEC that conducted the election becomes a nominal party in all of this. They just stand aside and look. So, and then the materials you need to defend, to prove that the elections were irregular, also you need to get from the man who conducted the election. And so that's why, like Fayose once said, they would rather not go to court. They would want to win at the poll. They would kill to win at the poll, because knowing fully well that even when you kill, maim, snatch boxes, the most important thing is once you win, the process is presumed regular. And anybody that is alleging irregularity will have an uphill task to prove polling unit by polling unit that they were irregular. And also, Doctor talked about security operatives. Our security operatives in Nigeria are compromised heavily, Also, we're talking about a situation where a chief judge of a state now, who ordinarily ought to be, an umpire, is surreptitiously dancing to the illegality that has taken place. So when you have all of this in the mix, what's left for you is a hopeless situation. I'm sorry to say. And then the people also are not happy matters. I once said somewhere that a country that neglects the education of our youth, you don't expect to see a prosperous country. And so when you turn around to say the youths are lazy, what do you expect from people you have refused to train, and those you have refused to educate? And so you have a large followers of hungry, poor, and uneducated people. These are the people who you in turn would want, to choose from amongst these political leaders. Then also, secondly, politics in Nigeria is not encouraging because it's not transparent. And so because of the violence, nobody would want to, serious-minded people would not want to be involved. And so you have a situation where the worst of us now go into the politics and begin to rule over the best of us. So when you have such a scenario, what is happening in Kogi now they will even tell you that at least it's better because the killings are not as, as much as it used to be. What is happening in Bayelsa, they will tell you, well, there will be collateral damage. But unfortunately, these collateral damages that we are accommodating, the world is laughing at us. That you can't protect your citizens, you can't protect your institutions, you can't conduct this day and age transparent election. We are still debating whether to use technology or not to use technology.
Liborous, let me ask you a question. Because we're talking about Section 188, and that's about the rule of law, and then we have a chief judge that we seem to have agreed could have acted differently. But are there circumstances when the Constitution can be circumvented?
Not at all. Not at all. The law is what it is. So
the chief judge of a state circumventing the law has done something illegal?
Yes, he has. That's why I said the NJC should come down heavy. Because here, the law is the law. It takes, the only way you can circumvent the law is when the court says, look, this process is not the way it is written. It can't be done this way, which is what the Supreme Court did in interpreting this same Section 188. To say, look, you can't invoke subsection 10 without complying with 1 to 9. And until that, in the absence of any interpretation to that effect, what should take place should be the letters of the law, what is written. And in this case, what is written is subsection 8 says, where the panel reports to the House of Assembly that the allegation had not been proved. No further proceeding shall be taken in respect of that matter. Shall. And so when that happened, and it is a public knowledge, it's a notorious fact that the allegations, these are the reports, they are public domain. And so even if the allegations or the report was not submitted to the chief judge, being a chief judge of that state, somebody who swore to uphold the law, you should have, okay, let me even see the report of the committee that I set up. And so, after looking at the report, I think it would have been in his interest to call the governor to say, what has happened here, you cannot defend. And so I would not want to put my signature or my seal to this action.
Okay, we're going to just change tack now and move to a different subject. This MTN debacle, having sent text messages round to all their subscribers that they're going to be imposing charges on USSD transactions, they've been forced to climb down, rather embarrassingly, when Dr. Pantami, the Minister of Communication, and the NCC have banned them from doing so. And they've sort of been left carrying the can. This is MTN. Bank CEOs are denying any involvement or any request to increase those charges, to impose those charges. Now, I'm not sure if you're aware, there's a leaked letter which claims the contrary, that the bank CEOs were aware and were involved. What's your whole prognosis?
First and foremost, it's quite unfortunate here that even when we have regulatory bodies, the investors or the companies dictate more to our regulatory body than the other way around. I expected that before that text message at all, what should have happened would have been, let stakeholders, that's why we talk about stakeholders meeting. Let the stakeholders sit down and agree on a framework before you even go ahead to impose, a tax. But here, it is easy and common for...
No, they don't say it's a tax. They say service charge.
That is a tax.
Whether it's service charge, any other name?
Whether it's service, because when we talk about service charge here, we're talking about I am paying for a service already. The call is not free, or the services are not free, and so you now impose another tax. You call it by whatever name. You don't just sit down, because here even price in senior societies are regulated. And that's why you have regulatory bodies. But a situation where you sit down and feel, okay, look, there's need because of whether the economic situation or because of the reality of the circumstance, the environment you operate in, there's need for you to charge a fee for a service. You ought to sit down with all stakeholders, the regulators primarily, to agree on the framework. And once that is done, also the regulator, it is the onus lies on the regulator to ensure that the people, the subscribers, are also aware and carried along, because the essence of being a regulator is to protect not just the investors, but also your subscribers, the people. But a situation where you just sit down and, in some cases, even some of these regulators have been accused at various times of compromising. And so that's why you have situations like this.
Absolutely. But then how can we also, as the people, even just trust the telcos not to charge us with mobile money, especially when you see new news coming out like this? Because mobile money is used by the masses who already don't even have the funds. And then we have situations like this. So where exactly does the trust come in?
What happened is, when you have monopolies, it's what happened. They dictate, the companies will dictate what they want to do. But when there is stiff competition, prices will come down, and then that's why government should provide, first and foremost, enabling environment for, and then you can only provide enabling, you can only dictate also to the companies when you provide enabling environment and attract investors, not by traveling abroad to go and woo investors, and yet the environment is not conducive for business. So that's the only way your people can enjoy the benefit of competition. But in the absence of that, they are going to be at the mercy of your so-called investors. And when the government is taxing in one end, the companies are taxing another end, and yet somebody sit down somewhere to say, well, Nigerians hardly pay taxes, or they don't want to pay for services. We all want to pay for services, but the taxes also should be commensurate to the services rendered. And it's quite unfortunate, really, because in all of this, at the end of the day, just like the charges on electricity, we'll debate it back and forth, and then someday you find out that these charges are smuggled in, and then we are left with it. It's really unfortunate that we have a system and we have a government that finds it hard at every turn to protect the citizens. You have companies it's only in Nigeria that you can start a business and rake in 100% interest, no apologies to anybody, in spite of the fact that you have regulators.
Well, but the regulators have stepped in, following the directive from the Minister of Communications. Do you think they have not managed the situation well after the fact? Even?
First and foremost, I would commend them 40%. Why? You didn't need to wait for the minister. You didn't need to wait for the minister.
Thank you very much, Liborous Oshoma.
Thank you.
Always a delight to have you on the Morning Show.
Absolutely.
Thank you very much.